A 21st May judgment of the Supreme Court has upheld as legal and valid an IBC rule that allows secured financial creditors to invoke personal guarantees given by promoters. Now, for banks, this was seen as a shot in the arm, especially considering banks that have been trying to reclaim assets and have piling NPAs have been taking haircuts up to 85 to 90% in some cases from bankrupt companies. But is it really working out that way is the question. Now, a personal guarantee given by a promoter has been taken in several cases where the promoter of the company has stepped forward to give a guarantee for a loan that the company is taking. The whole situation became a little complicated when the IBC process was put into place, and the Supreme Court now has cleared all doubts that personal guarantees will be invoked. There are several reports now that banks have been rushing to various courts and NCLTs in different parts of the country to invoke these guarantees, and at least 17 big defaulters have seen their personal guarantees invoked. What will be the outcome of this? What will this do to credit culture? Will banks really get any of their money back? Is the big question. To speak on this, I'm joined today by Sunil Mehta. He's the Chief Executive at the Indian Banking Association, Mahesh Agarwal, Partner at Agarwal Law, and Abizer Diwanji, Partner at Head at Financial Services, joins us today on the show as well. So welcome to all of you, and thank you so much for speaking with us. Mr. Mehta, let me begin by getting your take. So there are a lot of reports saying that we are seeing banks going to various forums, various courts, NCLTs to invoke these personal guarantees. Can you give us a sense of the scale of the situation? Does the IBA have a list of the individuals along with the exposure where these guarantees are being invoked?
Well, I really appreciate that the Supreme Court has upheld the lender's right to invoke the personal guarantee through IBC process also. Because invoking of a personal guarantee is not new. This is bankers have been using these personal guarantees as a risk mitigant in case of event of defaults, and this somehow ensures the skin in the game of the promoter who takes, because there may be corporates who are largely owned by one or two individuals or few major people, those who have an interest in those corporates, and they to give the comfort to the bankers, they give their personal guarantees so that the bankers take risk based on those personal guarantees. So since that has become a part of the CIRP process, and now the Supreme Court has upheld that yes, that guarantees can be invoked within this process also. But this remedy was available earlier also. Even under the DRT, the bankers were in a position to invoke these guarantees, but to have a two different set of recovery mechanism, it's a corporate debtor under insolvency process, there the courts will have a better view that what impact this guarantee will have, what value it will bring to the on the table, and how the resolutions will come faster. So I think bringing them within the fold of the CIRP is a very welcome thing. As regards this impact, since it has been announced recently on 21st of May 2021. So many of the banks are availing this option under CIRP, which earlier they were availing under the DRT Act or a different act. And exact magnitude, we don't have data right now, but this is a very welcome and thing for the lenders, because and now they will be able to invoke both the rights simultaneously against the corporate debtor as well as the guarantors.
Yeah, but you know, the interesting aspect is it's also coming in the backdrop of the global pandemic, which has obviously hit businesses. The IBC process was stalled as a result of this as well. And now creditors have this open route once again to invoke personal guarantees. Abizer Diwanji, what do you see as the impact? Now we know that more and more banks are going to go forward and try to invoke these personal guarantees. The question is this going to bear fruit?
Good question, Tamanna. You know, because it is now part of a legal process, and a complicated legal process at that, I think we will have to wait some while before it actually bears fruit. And I say this for a few reasons. The stand taken by most of the promoters, and I'm not for a minute for them, 2-3 aspects to look at. One is when you say that a business has been in CIRP, in the CIRP period, most companies run under significant constraint. And because the process lasts anywhere between 270 or 330 days, which is a year basically, it tends to impact business significantly. It doesn't hold enterprise value ever. And there is an argument, and I'm not saying it's a fair argument, but there is an argument which can get litigated, is that the business deteriorated significantly when it was not run by the promoter in the CIRP process, and hence the liability, the resultant liability to the promoter needs to be either reassessed or waived. Secondly, what we are seeing very actively happening is a lot of promoters are putting in alternative plans. And we've had the courts being more than flexible because we believe that justice delayed is better than justice denied, which is a problem. But what our courts end up doing is giving everybody a chance. I'll take the example of DHFL. It's out in the open, where the promoter has submitted a plan which says that I will pay you 100% of your principal back. This is the same guy who has defrauded the company of close to 20,000 crores and is evidence of proof. Now this person comes and says, I'm going to pay you 100% back. I think it's a mechanism by him to actually go ahead and say, my personal guarantees cannot be enforced because I offered to pay the full amount. So I personally think these factual litigations that will go on in the courts will not enable the bankers actually to bear fruit easily. Unless the courts, of course, take a stricter view.
Yeah. The question also is that will we then over time see the mechanism of personal guarantees then go redundant? Mahesh Agarwal, let me come to you with this point from the point of view of the personal guarantors, because we usually, when we talk about this process, we look at the top 10, 15 big defaulters who hit the headlines, who are being pursued in various courts and in some cases various arms of the law as well. But personal guarantees by promoters is a wider system that is being used. Is it feasible, first of all, to invoke all of these personal guarantees? And with these new rules coming into play, will promoters simply stop going in for personal guarantees?
Yeah, I would say like this, that this has definitely shaken the confidence of Indian businessmen. The entire entrepreneurship has been shaken. Now, let me just give you an example. That let's say a company has taken a debt of 10,000 crores. At that time, you take a personal guarantee from the guarantor. The banks usually take a net worth certificate of the guarantor also. At that time, the net worth given may be 10 crores, 20 crores, 50 crores, 100 crores. It is never 10,000 crores. The banks themselves know and they are sure that they are not going to recover 10,000 crores from a personal guarantor. So what is the purpose of the personal guarantee? The purpose was a deterrent to ensure that monies are not siphoned off, no fraud is committed, genuinely the business is conducted. Now we have seen cases because of coal cancellation or in the last 1 year because of COVID, companies have suffered huge loss. Now if a 10,000 crore company goes under, banks I'm sure cannot expect to recover the entire loss of 10,000 crore from the personal guarantor. Whereas they know that the net worth certificate was of 50 or 100 crores. So some mechanism has to be found. It's not that the personal guarantors are shying away, but to expect that the fruits will be 10,000 crores from a guarantor is ridiculous. So there has to be some mechanism to assess two parts. A, was the loss a genuine business loss or was it because of other forces? It could be court, it could be COVID, it could be some third party. And second, more importantly, what is the feasible amount of recovery which can be done? Now, instead of having cases which will go on for next 5 years into against the personal guarantors, ruin everybody and ruin the confidence of the businessmen, this is a time when the banks or the government should come forward with a scheme, a mechanism to understand if the monies have been siphoned off, they should definitely be recovered. If there's a genuine business loss, see the net worth of the promoter, see whether he can pay that much, recover that money and close the matter. What's the point of going for 10,000 crore against a person whose net worth is 50 crores? So some mechanism has to be found out.
I must get Mr. Mehta to respond to this. The efficacy of the whole mechanism of personal guarantees, whether it is even worth the paper the guarantee is written on in the context of the COVID-19 pandemic, and do bankers really hope to get much out of this?
So, two things, as rightly said by Mahesh also, and I'll try to give you a different perspective. A personal guarantee, bank do not expect that the entire money will be recovered from the personal guarantor, because that is not what is envisaged at the time of giving the loan. But it is basically skin in the game. So, skin in the game means a promoter, when he comes out with a project, then he should feel confident of taking that risk, because bankers are dealing with the public money, and public money, if they are putting at risk, the person who will be holding that asset, will be managing that asset, will have a full control over that asset. He should have enough commitment, because if he doesn't have enough commitment in the form of a margin or in the form of a guarantee, then how the lenders will feel confident of lending to a project, because the promoter himself is not confident of its success if he is not confident about it. So that's why that guarantee becomes an enabler as a risk mitigant for a lender to deploy the public money. And so long as the process of lending is there, I think guarantee is not something new. This is a very age-old practice which has going on in the banking system for ages. Like I have been in the banking industry for 40 years, and from the day when the first loan we have made, I think guarantees were a part of the loan agreements everywhere. It is for a smaller loan and bigger agreement. And this guarantee gives a comfort to the lender while lending to an entity that besides this entity, the promoter of the entity or the person who is guaranteeing that the repayment will also ensure that the public money comes back and can be recycled for the industrial use. So it may not have that much of the monetary value, but it definitely had a psychological value. It's a pressure on the promoter also to perform, to bring out, to meet out the commitments which were made while kicking the project, and that's in the process enables the credit growth of the country. Unlike so there are different type of models also. Like sometimes bankers lend based simply on the asset base, like housing loan, where they know that the house is mortgaged, or totally a loan against the properties, where they know the property is mortgaged. They do not insist for mortgage guarantees, because they know that they have got adequate backing of the assets for funding that. But there are projects which are totally cash flow based, especially the say EPC contract, the contracts where we don't create such tangible assets which can be recovered in the event of default, where if the promoter do not have a skin in the game in the form of a margin or a guarantee, then it can put a public money to a lot of problems. So I don't think that the guarantee has giving guarantees or stipulation of the guarantees have ever been a challenge in availment of the credit, because there are entrepreneurs who always take risks. They take risks, they make money, they create wealth for themselves, they create wealth for the society, they create employment for the society. So that is an ongoing thing. I don't think it is only this decision has made any difference, except that instead of those guarantees being invoked in the DRT, now it will be simultaneously invoked in the CRP process, so that two different legal processes do not run simultaneously. And better appreciation of the situation can be done at one forum.
Yeah, in the last, I would say in the last year and a half, or even since November 2019, when these rules first came into force, have you seen a change in the eagerness of promoters to come forward for personal guarantees, or is this going on as usual? Is it business as usual, or has this had a chilling effect on promoters?
If you ask my perspective, I think it is a business as usual. There are corporates who have established their credentials, those who have established their ratings, those who have established their credit ratings in the past, and they have worthy. So bankers even do not ask them for guarantees, because they know that they have got enough and adequate good track record which may not warrant guarantees. But when the banks are lending public money to an entrepreneur who doesn't have a very great past track record, or where they know that the availability of the assets and the securities may not be enough, then the guarantees are stipulated. And I don't think the demand for a guarantee, because it's on a case-to-case basis depending upon the situation. As I told you in advance, that in case of mortgage-based loan, where banks think that they have got adequate asset coverage for that lending, They may not insist even for guarantee.
Sure.
In cases of corporates where they think that the past track record and the credential and the governance is good, they may not insist for the guarantees. But where they think that yes, it is a bit risk in lending to the public money, and they need a mitigant in the form of a guarantee. And if the entrepreneur wants to come out with a business, then they also take the risk and come out with the guarantees, and it works, and it is going on.
Okay. Abizer, do you see anything concrete coming out of this process and invocation of these promoter guarantees? I mean, to look at the context, deep haircuts that banks are taking, the pandemic also looming large, and then this public perception that willful defaulters seem to have gotten away with it all. So also that sense that, promoters who have defaulted willfully should have to pay their pound of flesh.
Oh, so that is true, Tamanna. Promoters who have willfully defaulted need to pay a pound of flesh. But alternatively, let me tell you, I would like to just give a balanced view to what Mr. Agarwal said and what Mr. Mehta said. One is, our biggest problem in the system is criminalizing default. And that is a big issue for us as a system. Any person who has defaulted is deemed to be criminal. As Mr. Agarwal just said, there have been various circumstances under which people would have defaulted. And the banks need to use their discretion on where to exercise the personal guarantee and where to accept a genuine business loss. And I think that is not difficult to ascertain. To say that any person who has defaulted is a criminal will lead to a disincentivization for entrepreneurship to run in this country, for sure. On the other hand, I have actually seen this behavior where there is perception that a particular promoter has siphoned off funds. I have seen the body language of bankers to be very different to those who have not siphoned off funds and have been genuine business failures. What we need to get over, and maybe what the bankers need to be spared in terms of public perception, I say this because this is a public debate, is that every person is not a defaulter. If that decision making, where if the public at large do not pass judgment on this and allow the bankers to pass judgment on it, you will find much better behavior from the bankers towards the entrepreneurship, and you will find entrepreneurs that willingly giving personal guarantees. In today's environment, nobody wishes to give one because they know that even if there is a genuine business failure like the pandemic, for example, their personal wealth is at risk. Why would anybody do that? So my view is what is required is a balanced approach. Yes, the law is there, and the law should be used judiciously where required. And where required, please go after the guarantees. But where not required, even demonstrate that we have let go because we have signed off it to be a genuine business loss.
Mr. Agarwal, do you sense that right now in the current context, so pandemic on the one hand, a lot of businesses hurting, a lot of bad debt also piling up, and on the other hand, you have banks under a lot of public scrutiny and pressure to get their books in order. Do you think this is creating a sense of unease for promoters who have given personal guarantee?
It is definitely creating unease, but I am with the banks that once they have a personal guarantee, there is a document which is signed, that also has to be respected. We can't say that you throw it in the dustbin, banks should not take any action. We are not suggesting that. But the point is, like Diwanji also said, that a reasonable procedure has to be followed. Take an example, that a hotel is set up by somebody, he puts in 20 crores, 80 crores is given by loan. Now when you talk about skin in the game, nobody is talking about the equity. A person, when he sets up business, puts in his own money in the business. 20 crores is set up, 80 crores by the loan. When the company goes under, his equity is gone. That skin in the game is already there. Over and above that is the personal guarantee. Now when you make an assessment, banks know the business. Banks know why the losses have been suffered. They know the situation. When they know a situation, they can assess that there is a genuine business. It has gone down. This person has already lost his entire equity. His entire investment has gone. Bank has also lost the money. Therefore, some procedure, it's a systematic issue. A systematic answer has to be found. Some procedure has to be followed. Instead of going on with the cases for next 5 years, some settlement should be worked out, and so that the banks do not take the flag from the public that a PG has been ignored. Action must be taken, but a balanced action should be taken so that recoveries made of what is possible. Now, if you want to recover 8,000 crore or 20 crore from a small person who doesn't have money, what is the point? So therefore, some settlement talk, but there is no procedure like that as of now. Some procedure has to be made out. That will give confidence to the entrepreneurs who are giving business. That will give confidence to the bankers who have to recover money. So a balanced approach has to be undertaken.
Yeah, so Mr. Mehta, concluding remarks, do you think that there is a need to relook at the system and the discretion that banks have? At the end of the day, it is the discretion of the banker to invoke that personal guarantee, to take that personal guarantee in the first place and ensure that that personal guarantee actually means something rather than a symbol. And then also when to invoke it in the context of a pandemic. So do you think there needs to be a system, or should it be left to the discretion of the banker as it is right now?
So I think it's a very valid point which you have raised, and I think there is a need for a system, and the regulators as well as the legal system has recognized this need, and that has already come. I think you must be aware about the pre-pack insolvency package, where a regime has already been created, especially for MSME. That before going to insolvency, a pre-arrangements can be made, even scaling down of debt can take place, a restructuring can happen, and where the guarantees may not be invoked, but the entity may be kept as a going concern, and despite haircut, and that is a totally process which is vetted by the NCLT. So under that pre-pack mechanism, these options will be available to are available for MSME right now, and can be made maybe once this succeed in MSME, this can be extended for the other sector. So I must appreciate that our government and regulator are already and this IBBI are already working on it and devising some third method where a value of the enterprise, a corporate company, can be preserved by having a pre-approved arrangement with the consent of the majority of the lenders, say 66%, which can get the blessings of the NCLT by within 30 days of that resolution plan, and that is put to that company is protected, the employment is protected, the interests of promoters are also protected, the guarantors are also protected, and it is kept as a going concern in the largest interest of the entire ecosystem. And I fully agree there can be reasons where the default can be on a genuine reason. There can be various reasons like pandemic, there can be reasons like legal changes or the market obsolescence or the natural calamities. There can be thousands of reasons. So there can be reasons which are beyond of the control of the promoter. And to address those issues, the pre-pack regime which has already been introduced for MSME, if the similar pre-pack type of arrangements can be brought out into the other sectors, this can easily facilitate and give a discretion to the corporate entity also, the guarantors also, and the lenders also to work together to work out a new resolution that can sustain this enterprise in everybody's interest. Bankers can realize the better value. The promoter can also protect the value of of their investment, and the employees can also remain their employment. And these type of changes into the laws are important, and I hope the system is working on it. And once it succeeds, it can be expanded to the other larger and medium and larger industries also, and the businesses also. So that is my expectations from this system.
Yeah. Abizer, where do you see this going forward now that banks have that backing to invoke personal guarantees, and several of them have already begun, more surely will? Do you see a pushback coming in, or how do you see this whole situation panning out?
No, so I personally think that it's a good legislative enablement given to the banks. And clearly, now that you have IBC, and through IBC you could do it, you can't arbitrage among various other laws, so there is no escaping out. It's a good thing, and I think now that we have a Supreme Court level judgment, at least the fact that they can be invoked or no has been cleared in law and established in law. Factual situations in each and every company will get debated. I think for any means, guarantee should not be considered as a security by bankers. It's a fallback. It's a fallback where you believe that personal enrichment has happened at the cost of business. And it's only in that situation can the fallback be invoked or should be invoked. Otherwise, I think it's pretty much the security, and cash flow is also a security, based on which lenders have lent money. And if their projections have gone wrong for various reasons, as Mr. Mehta just said, we should be cognizant of that fact and accept it. I think once we see that behavior from the lenders, we will find that people will be more amenable to give personal guarantees in future. If we establish a regime where any kind of default is criminalized, and we will not find people taking entrepreneurial risky decisions. Because as Mr. Agarwal just said, it's more than the capital which is at stake. While they have lost their capital, if they're 5x leverage, then they're exposed to 5x of their capital, even beyond what they have spent. So ideally, it would kill entrepreneurship. But what I would say is that if lenders lend based on the business as it is and use personal guarantee as a fallback, we will actually see the system work very well.
Mahesh Agarwal, in conclusion, how do you draw the balance? Surely corporates or promoters who have given personal guarantees can't wish them away because there was a pandemic. They also have to be liable for the guarantees that they have given. So how do you hope to see this situation evolve, which is fair to all sides?
For example, take a case where the recoveries under IBC are substantial. May not be 100%, maybe 50%, 60%, 70%. If substantial recoveries are there, that itself shows the business was genuine, the loans which were taken were genuine, they were actually invested in the business, but the company has lost money and the company has gone into IBC. If there are recoveries made, there has to be some leniency shown to the promoters. Secondly, if a loan is an old loan, say of 10 years, 15 years, 20 years, every year you take a personal net worth certificate from the promoter. You are aware what is the personal net worth, which may be X, Y, Z, whatever amount. You know what is the maximum recovery from that. Enter into a settlement, ask that person, you must pay this amount, otherwise we'll take you to IBC. There are many ways where it can be done, and a systematic solution has to be done. For example, in GST, income tax, various legislations, there have been amnesty schemes, there have been settlement schemes, there have been procedures which can be even now found, like the pre-pack mechanism in MSME. If that is extended, that's an excellent scheme, which can be extended along with the resolution process of the company. The resolution of the guarantor can also be resolved. So a full amount is settled, and that amount is settled, which will give confidence to the businessman. Today, what we need is to recover the money for the banks, and B, give confidence to the businessmen to set up new business, set up new industries. Ultimately, for growth of the country, we need this businessman. You can't kill the businessman and say, now only the banks should get the money. There has to be a balance.
Let's hope that balance is achieved going forward, because yes, banks need to straighten up their balance sheets and businesses need to continue to thrive and grow if we have to revive from the impact of this pandemic. I want to thank all of you for joining us on this discussion this evening.